Okay, class, I'm a little disappointed that my camera appears to have shut off, but we're gonna just have to make this 2 videos because, again, like I said, I don't have my video producer to fix it. So when I pushed pause, it turned off. We're gonna pick up where we were on video 2. I guess we'll call this 3 now. Again, we're talking about a mobile home case. It is governed by the UCC because the mobile home is a good and the seller of the mobile home is a merchant. Now here's the story. The Borsage couple, the Borsages, lived in a mobile home from August of 1983 until March of 86. 31 months. That's almost 3 years. Yet the court ruled that when they revoked acceptance, when they called the mobile home company after 3 years of problems and said, hey, look, we're done with this mobile home, come get it, take it. When they called and revoked their acceptance, even after all those months, the court said that revocation was valid. Why? Here's the important point of law. We're skipping right to the end and then I'll go over the case. I know we just started, but I'm telling you the ending. The court says the buyer reasonably believed that the nonconformity would be cured, but it was not cured within a reasonable time. So the court says it's okay to revoke acceptance because the buyer accepted the mobile home believing that the problems would be fixed in a reasonable time, but they were not. And after 3 years, that's a reasonable time. That's way too long. That's plenty more than enough time. Problems still aren't fixed, so the court says the buyer can get out of it. They can revoke acceptance and wash their hands of this terrible deal with this company. Imagine this scenario. Here's the story. You're a young couple just starting out. I don't know, let's say you're young. You're real young. You just got married. You're 23 years old. You tour a mobile home that is described as, hey, this is the Cadillac of mobile homes. You're going to love this place. Right? That's my car salesman imitation. Now that, by the way, the Cadillac of mobile homes, you're going to love it. I got to have a gold chain on too. I feel like you need a gold chain to sell cars or mobile homes. That's mere puffing. Remember puffing from BA 3301, Legal Environment Business? Puffing is just things like when they say, you know, Gillette, it smells like a man or whatever it is. That kind of stuff, it's not a factual based statement. You can't sue over it. You can't prove it right. You can't prove it wrong. It's just puffing. It's just the kind of stuff that people say means nothing. If they say this Toyota is going to get 58 miles to the gallon and you buy it and it gets 22 miles to the gallon, that's not puffing because it's something that can be measured and proven and you could sue over it. But if they tell you, you know, this Toyota is the most beautiful car ever made, that's just puffing. And also it's an opinion, right? Well, anyway, so they tell these people, this is the Cadillac of mobile homes. You're going to love it. And they purchase it, okay? Or as I said, you purchase it. You're 23, you're in love, you purchase this mobile home. What was your mistake? Was it living in a mobile home, or as some people call it, a tornado magnet? No, that's not your first mistake. Their first mistake, this couple in the story, the Borsages, their first mistake was they only inspected the mobile home at night and the power was shut off. What are you thinking? What you know, anyway, so they wander through the mobile home with flashlights, I guess. And trust me, in 1992, the flashlights were not what they are today with LED bulbs and everything. I mean, back then, you could cram as many batteries as you want. It's pretty weak and horrible lighting. I remember, there was never a good flashlight in the 90s or the 80s. And I have a flashlight now. It's like a car headlight walking around out here in the country where I live. And I mean, you could see it feels like a mile. The thing's so bright. Well, these people wander through this mobile home in 1992, I guess with flashlights, because it's nighttime, the power's shut off. That's your first problem. Like, what was your first sign of that's a problem? Anyway, they inspected the home in the dark and they agreed to buy it, you know. I don't know what they were thinking. Then they come back a few days later, I guess they move in and they begin to discover problems. Hey, the water leaks and there's mold and hey, these moldings around the ceiling are loose and the dishwasher door doesn't shut quite right, which that's a big problem, right? It's all that water flying around. The bathroom door has a warp in it. The walls have holes in them. There's a problem with the heating and the air conditioning. And the cabinets have chips and holes in the cabinets. And the furniture's falling apart. And there's mold. And there's mildew. And rain is coming in at night when it rains. And the doors and the windows don't work right. I mean, that's a lot of problems. I used to be a landman, an oil and gas landman, running around all over Texas, working in little small towns, and then I would come home, usually on the weekend. I rented an RV, not a mobile home, but an RV. I rented a couple RVs. One was awesome, spent about a year in it, a year of weeknights, you know, in Midland. I rented another RV in the town of Andrews, and every time I came back on Monday from coming home to Houston or Waller, I'd go back up there on Monday, and the RV'd have rat droppings everywhere. And I immediately figured out where they were coming in and out. It was a hole this big. And I was like calling the guy, the landlord. I was like, can you fix the hole, please? It's real easy. I'll fix it for you if you want. And then you'll pay me for it. Well, he came in and he got it fixed. And that was the end of it. I never had another problem with rats or mice or anything. That's not the story here for the Borsages. They're calling. The guy comes out. They don't do anything. The AC guy comes, he puts an air conditioner on the ground, but he doesn't install it. And the heater guy, they come, they bring some equipment, but they don't do the job. The roofing people, they come, they do a little work, but the roof still leaks. I mean, it was just problem after problem after problem. And renters, I'm sure you know, renters aren't supposed to have to pay for these things. That's the whole point of renting. The landlord's supposed to do all the repairs. Now these people, they bought the mobile home. They didn't rent. That's cut what I said. It's a purchase. It's not a rent. The whole point of the UCC is purchase of goods. I got off track there. Got a little too passionate about this case. They're not renters, but when you're a brand new buyer, the supposedly newish mobile home should work. Or even if it's a used mobile home, you ought to be able to move in and not have all these problems. I mean, when you buy a house, you expect them to fix all the problems, but they bought this mobile home, and now I've used the word landlord. That's also a mistake. This is not a case about renting and landlords. It was the North River Homes Incorporated is the company selling the mobile home. So North River Homes Incorporated comes out but doesn't fix their goods, their product. And that kept happening and kept happening and kept happening for a year. Then it was 2 years. Finally, it was almost 3 years. So here, let me read my notes. The Borsages complained, and the repairmen would come, and they would do very little, and they would leave things no better, and sometimes they would leave things worse. One time they had a guy crawling around underneath the mobile home, fixing holes with masking tape, not duct tape, okay? And duct tape, I hope you know, is the worst way to fix anything. I mean, it's not how you fix anything to do with a house or a car. I mean, duct tape is a temporary solution to get you through the weekend before you can get it fixed right, you know? Well, anyway, he's crawling around under their mobile home, patching holes with duct tape, and it actually damaged the floor and made the floor bow in some way and caused more leaks. I don't know exactly. Okay, so people would come, make things worse, drop off parts, but not bother to install them. And in every way, the Borsage couple is getting the runaround. So in October of 1984, because this case started at 83 when they bought it, in October of 84, they stopped making payments. And then in March of 86, so roughly 6 months later, 5 months later, they told the seller, hey, come pick up your mobile home. We're done. Because they still have their little space in the mobile home park. So they need that one mobile home out so they can move a new one in and keep their spot in the mobile home park. So they called North River Homes Incorporated and said, come pick up your mobile home. And North River Homes said, no, we're going to sue you to pay us the rest of what you owe us. They ended up in court, and the court said, hey, the buyer can revoke acceptance even if it is 30 months after the purchase, because the buyer reasonably believed the non-conforming goods would be cured. The buyer, the Borsages, they reasonably believed, because probably the North River Homes told them 100 times, oh yeah, we'll be out there next week, we'll fix it. We'll be out there Saturday, we'll get everything done, get it all squared away. We all be good as new. I mean, I'm sure they said that stuff 1,000 times. So the Borsages reasonably believed that the nonconformity would be cured, but it was not cured within a reasonable time. So, under the UCC, they're allowed to revoke their acceptance because the nonconformity was not cured. That was the first point that I gave you under revocation. Buyer may revoke if the buyer reasonably believed the nonconformity would be cured, but it was not cured within reasonable time. So he gets to revoke. All right, next case we're going to talk about. Totally different case about a station wagon. Let me show you a picture of it, and I'll put these on that, like I said, I'll provide these for you. This case is called Colonial Dodge versus Miller, 362 Northwest 2nd, page 704. That's the Northwest Reporter. It's a lawyer thing, but that's what volume it's in. You ever watch a lawyer TV show or a movie, or if you're working in a law office, there's just books and books and books and books that all look exactly the same, super boring the way they look anyway. I mean, they don't make you want to buy them, but they do match all those books, and now it's all on computer. That's what this is at, 362 Northwest 2nd. That's the Northwestern Reporter, 2nd volume, page 74, Michigan. Key point, I always like to tell you the state and the year. It's Michigan, 84. Doesn't matter that it's not Texas because, again, we're talking about the Uniform Commercial Code, so the Michigan statute is probably going to be the same as the Texas statute on the issue of revocation under the UCC Article 2 for the sale of goods. Now, the station wagon. Here's the story. In April of 1976, the bicentennial, Clarence Miller ordered a new Dodge Royal Monaco station wagon from Colonial Dodge in April of 76. And I like to call all the SUVs today station wagons. To me, anything with a hatchback, even if it's a Porsche, even a Rolls Royce, they make a hatchback now. I like to call it a station wagon, especially when I see it go by on the day of Beyonce's concert and it's a big white Rolls Royce with a hatchback, blacked out windows, and I'm like, there's Beyonce in her station wagon. Anyway, this is a classic station wagon, though. I mean, that's what they were like. First point, April 1976, Clarence Miller buys the Dodge Royal Monaco station wagon from Colonial Dodge. Number 2, after the Millers brought the car home, they noticed it had no spare tire. Number 3, Mr. Miller says, I gotta have a spare tire because I'm on the road all the time. Number 4, Colonial Dodge told him, well, there's no spare tires available. I mean, sorry, what are we gonna do, There's no spare tires available because there's a labor strike. So that was 1976, 40 something years ago. It's funny that it kind of reminds me of today's supply chain problems. But anyway, there weren't any spare tires. So he's got his 4 tires, but if he has a flat, he's going to be in trouble. And there was no discount tire company in 76. But you could go to the gas station and hope they could find you a tire that would work. But anyway, he needs a spare tire because he says, my car, if it breaks down at 3 a.m., I'm not sitting in some seedy, crime-ridden neighborhood till daylight. I want to get out of there. Well, anyway, for Mr. Miller, for this particular man who is a road warrior, he's driving all the time, Mr. Miller says, if I don't get a spare tire, that's a deal breaker. I mean, I'm out. I'm out of here. You can take the car back. I'm going to stop payment on my check because I need a spare tire. So the deal's off. I called the bank already. They're stopping payment on the check. Send somebody to pick up the station wagon in front of my house because I'm not buying it if there's no spare tire. Now, would I do that? No. I used to be a road warrior. I used to drive 2,000 miles a week some weeks, all over West Texas, and then all the way back to Houston, my Toyota Tundra. Tundra. Anyway, I put a lot of miles, 2,000 a week sometimes, but I would probably have kept the car even without a spare. But I'm not Mr. Miller, and it's his decision. So he says, I got to have a spare. It's a deal breaker for me. I got to have a spare tire. Deal's off. Mr. Miller stopped making payments. He stopped the payment on that very first check, probably the deposit, and he made no further payments. And then This is the crazy thing. The car sat in front of his house until the tags expired on the car, and then the police towed it away. I mean, the car was just sitting there getting dirty with those little streaks of dirt running down on the side wind mirrors and stuff. And, you know, there's leaves collecting around the tires. You can tell the car hasn't moved in a year. Finally, everything expires, and then the police tow it away. Well, at some point, Colonial Dodge, rather than repossess the car, which they would have been easy, they left it out there all that time. And at some point, Colonial Dodge sued, okay, to get the money. They're like, you owe us for the whole car. And Mr. Miller's like, no, I told you I wasn't paying for it, and I told you to come get it. And this is a case of people being stubborn and stupid, okay, honestly. Mr. Miller was stubborn, and he should have driven that station wagon back, you know, and left it up there at the dealership. You know, then at least it would have been, they'd have had the car. They probably would have sent him a few letters and then forgot the whole thing eventually, you know, and it would have gone away. But because he didn't even have the courtesy or the wisdom or professionalism to drive the car back to the dealer, I mean, I know he was mad about the spare tire, but just take the car back so it's off your property and out of your hands. Well, anyway, I wrote a note about this. I said, by the way, doesn't it seem like something is wrong here? Both parties are ignoring a car and it's just sitting on the street. Anything could happen. The selling party, the dealer, should tow the car, and they should sue for the purchase price, and they should sue for damages to the car, and maybe sue for the cost of towing it back up there. They might not win, but they could at least say, look, we'll come get the car, but you're paying for the tow truck. Or really, they should have just come and said, give us the key and we'll drive it back to the dealership. But for whatever reason, neither party was willing to budge. They both acted stubborn, which is real common in lawsuits. And that's how you end up in lawsuits, just people being idiots sometimes. Not every lawsuit. Anyway, the parties should have handled that. You don't leave the car out there because you know what happens? It's a big, what, 5-letter word? W-A-S-T-E. Waste. Why are you wasting the car? Both parties are allowing a pretty expensive asset to sit there and turn to rust. It's a terrible thing. Both parties should be held, in my opinion, somewhat responsible just from an economics point of view. You both failed if you left that car sitting out there. And also, the whole problem would have gone away if Mr. Miller had just driven the car back himself. But I understand he didn't want to, and he was mad they didn't give him a spare. And I understand that too. Okay, so the seller, really, ultimately, I think the duty, in my opinion, the duty is on the seller. But this is not part of the UCC lesson for today. It's just me telling you some legal stuff. But the seller has a duty to mitigate his losses, okay? That means, I mean, in a case of breach like this, it doesn't matter if you're the seller or the buyer, but in this case, the seller should get the car back and sell it to someone else. And then the only problem, maybe you could say, well, Mr. Miller owes us for the difference between what he would have paid and what that second guy paid, because maybe now we're calling it a used car. I don't know. But at least you've reduced the damages a tremendous, maybe 95%. And then you go for Mr. Miller after the small little difference between his price and then the price you later sold it for, which maybe was a little bit less. Anyway, the seller has a duty to mitigate his losses. And that means to me that the seller should have gone and got the car. But that's not what happened. Back to the case at hand, the plaintiff, Colonial Dodge, argues that in the absence, they said the absence of a spare tire does not, quote, substantially impair the value of the goods delivered to the buyer. That's a good argument, right? With a missing spare tire, a $10,000 car is still worth about $10,000, okay? I mean, that's one missing tire does not really substantially impair the value of the goods delivered. It's not that big a deal. I mean, financially, on paper, the car's still almost as valuable as it would have been with the spare tire. You might be $100 in the hole back in the 70s, maybe at the most, maybe $75 in the hole. But the defendant would argue that no, in my opinion, or the defendant's lawyer, that is the buyer's lawyer, Mr. Miller's lawyer, would say, no, in my client's opinion, That spare tire is the difference between life and death. It's like a life jacket on a boat. You can't sell me a boat without life jackets because we get out there and then we die, right? A life jacket is a lifesaver. And to my client, a spare tire is a lifesaver. He has to have a spare tire because something could happen in the middle of the night and he's out on the road at bad, weird hours. And anyway, the appellate court agreed with the buyer. Okay, the appellate court agreed with the buyer, Mr. Miller, who said, if there's no spare, there's no deal. The appellate court said, quote, the defendant's concern with safety is evidenced by the fact that he ordered a special package which included spare tires, and the dangers attendant upon a stranded motorist are common knowledge, and Mr. Miller's fears are not unreasonable. Okay? The defendant's concern with safety is evidenced by the fact that he ordered a special package which included spare tires. The dangers attendant upon a stranded motorist are common knowledge. We all know what could happen. Mr. Miller's fears are not unreasonable. And finally, so although Mr. Miller had accepted the car before he discovered the nonconformity, that did not preclude revocation of the deal. Okay, the spare was to have been stored under a fastened panel concealed from view. So that takes us back to that second point, which I told you that said a buyer can revoke the deal if buyer, well, let me say, here's what happened. Buyer accepted because buyer was unable to discover a latent defect, thus missing spare tire, which could not reasonably have been discovered before acceptance. Okay? So the court says what happened to Mr. Miller is reasonable. It's normal that you would inspect the car, drive the car, test drive it, everything else, take it home, and then only later discover that that there was no spare tire. So he's allowed to revoke because buyer accepted because buyer was unable to discover a latent defect that could not reasonably have been discovered before acceptance. And that is the end.